Yes, thank you, Caroline and Elizabeth, for inviting me. I'm very happy to speak here today. One of the perks, I think, of the pandemic that's become clear is the ease at which we can now all communicate, because certainly from my own point of view, these kinds of talks would have been extremely difficult to manage, particularly on a national basis. So I'm very happy to speaking to so many people in so many different locations. My talk is on the Manolete decision, which I would be shocked if any of you have not already come across or read at this point, given the wide implications that it has for the way that litigation is managed in the insolvency context. What I am going to do, in light of the fact I imagine most of you already have plenty of experience with it and what it means, is touch really on its interplay with the CPR that insolvency litigators will now have, which, while I imagine most of you will have at least a cursory knowledge of, there will be slightly more detail available to the extent that now Part 7 becomes the default for certain kinds of claims, if that is the way that the market goes. So if you are living under a rock or you haven't read the decision, the very brief summary of it is that Manolete took an assignment of various claims from an insolvent company that were then pursued against the former directors. The claims included various breach of duty claims, and all of those claims were brought by a single Insolvency Act application. All of that is entirely standard stuff and probably wouldn't have been out of the ordinary for anybody on this call. Now, interestingly, the respondents took a point based on the decision of His Honour Judge Mark Corson QC when he sat as a Deputy High Court Judge. Of course, he's now been elevated to a full circuit judge with specialist jurisdiction in Manchester. But what the respondents sought was the unless order requiring the applicant to pay the issue fee that would have been payable had the claim been commenced by way of a Part 7 claim. There was a decision of Judge Corson called Taunton Logs, which I may touch on later, but that had a slightly different angle concerning administrators and a claim that was alleged to be wrongly pursued. But in that claim, what Judge Corson did was essentially treated as a procedural irregularity, albeit not under Rule 12.64 under Part 3 in the court's wider case management powers under the CPR, and require that in order to regularise it, a issue fee would be paid. You might ask, why would the respondent seek this kind of order? To which the response would, of course, be, that's quite a good question. In the event that the litigation funders here are successful, the costs of the issue fee would, of course, be pursued from the respondents. So one can only speculate as to either they consider they have a very good claim, or that this is perhaps a tactical decision intended to just increase the complexity or the frustration factor for those funding the litigation. Arising out of the decision, and two of the things that we're going to be considering today, is can the assignees of a claim from a liquidator use the 212 gateway that we'll all be familiar with? And in other terms, what the applications that are made under the Insolvency Act regime, which of them can be, and for those that are wrongly made, what's the court going to do about it? So pausing back and stepping back a slide for a moment, they were asking for the issue fee to be paid. Aside from the obvious why question to that, a large amount of that is probably answered by the value of them. The Insolvency Act applications attract really a nominal issue fee, which isn't going to raise any eyebrows. As you can see here, these are, I believe, the up-to-date issue fees, albeit this is not the element that I typically deal with, so I'm sure Caroline or Elizabeth will be able to correct me if I'm wrong. But these are the sorts of fees that are payable in a typical claim that you might bring, let's say, for debt. Given the type of practice we all do, it wouldn't shock me if the vast majority of the claims that are run would be attracting high issue fees. So where you can see they're greater than £10,000, but no more than £200,000, that's 5% of the value of the claim. Anything over £200,000 attracts a flat £10,000 issue fee. Now, anything that is less than £10,000, of course, would typically be a small claim run under Part 7, to which there are incredibly ungenerous cost consequences for the successful party, which is why I envisage most people on this call would be pursuing claims that either attract 5% of the value or £10,000. To the extent that they are updated with semi-regularity, they're normally up to date on the government website, but the current fees orders are enclosed on this side should you wish to check them. The implications of the high upfront issue fees are fairly clear. Aside from being incredibly inconvenient, it is a upfront investment, and you're essentially required to pin your colours to the mast, put your money where the mouth is. There's less ability to chance it with the first application in hopes of a quick resolution, because the moment that the train starts running, it becomes very difficult to escape without cost consequences. So that can be incredibly expensive. So when you are considering whether to bring a claim, no doubt whilst before the costs of the issue wouldn't be a particularly troubling concern, it is now an enormous disincentive and likely to cause any office holder or litigation funder pause for thought before bringing their claim if it is one that is impacted by this decision. I've already dealt with why the respondents seek this order, which, as I say, it was a surprising order to be sought, but there we have it. So stepping back for a moment, where has all of this come from? Everybody will know Rule 1.35, and I've enclosed the 2 paragraphs of the judgment that deal with this. What it is describing is things entitled, which the judge has conveniently described as insolvency proceedings. And most of the applications that I'll shortly come on to would be wrapped up within that wrapper. Paragraph 26, and this is really the heart of where we got to. The insolvency application that is made, it must state that is made under the Act or the rules. So pausing there, if it is not an insolvency proceeding and if it does not fall within the parts that I've described and highlighted and read as parts to 11, then you would potentially be unable to state that it is made under the Act or paragraph as applicable. So the last 3 lines on the slides there, the important ones. It follows that if an applicant is not able to state that the application is made under the Act or rules, it is not appropriate to make the claim by way of an insolvency application, as Rule 1.35 cannot be satisfied. So taking a step back for a moment, the avoidance provisions that everybody will be familiar with, fraudulent trading, wrongful trading, TUVs, preferences, extortionate credit transactions, all of those within the definition above fall within the insolvency proceedings that the judge was describing. So the implication of that is, of course, if you were, for example, to bring a TUV claim, you could state on it, this is a TUV brought under Section 238, and you could set out the paragraphs within the Insolvency Act that you're relying on more generally, and all of that complies and can be entirely brought by an Insolvency Act application. So where lies the problem? When dealing with misfeasance, which is something we're going to come back to in a moment, I imagine, again, all of you will be familiar with it. But what you will understand about Section 212, if I move forward, is that it is not of itself a cause of action, it is a gateway or it's a procedural wrapper. So what do I mean by that? It means that if the company had a claim against the directors prior to the liquidation, then of course the liquidators now have a claim. If it did not, then the office holder does not, and it is that simple. So the implications of the Manolete decision. A claim made pursuant to Section 212 is not a transaction avoidance provision. It is often used to bring claims vested in a company in liquidation for the purpose of restoring assets. Once restored, the liquidator may realise the assets and make a distribution to creditors. So all that is doing is wrapping up in one neat paragraph what I'm saying regarding it being a procedural wrapper. So again, slightly different distinction to the avoidance provisions, and let's put a mental tab stop there. Other claims, which we often touch on in insolvency, you can see that what's been assigned here to the liquidators to the funder, it says all and any claims that Blackwater, being the insolvent entity, may have such claims to include breach of duty of common law, breach of fiduciary duty or statutory duty, or other legal or equitable duty, any claim in fraud, whether common law or equitable fraud, conspiracy by unlawful means, and or any claims under the Companies Act. So that is, of course, an incredibly broad spectrum. But what is important to note is, of course, is that none of those constitute insolvency proceedings. And no doubt many of you can see where this is going. So in terms of the categories, and these aren't, I would say, binding categories, but just convenient groupings for the purpose of this decision, we've got claims that constitute insolvency proceedings. So that's either whether they are their own cause of action or simply a gateway or procedural wrapper. And then we have claims other than the above. And a good example of that is a entirely ordinary debt claim that you might bring for, let's say, overdrawn DLA. So going back to Manolete, what had happened? The liquidators had assigned to the funder hybrid claims. So this is where I say they were all brought under one Insolvency Act application. And again, I can't stress how ordinary this would have been prior to this decision. So an example of this, let's say, is a claim for preference brought by an Insolvency Act application. And there's also a smaller component of the claim and arising from the same facts to do with, let's say, a debt owed to the company. What would previously have been done is that the debt claim, whilst ordinarily that kind of thing wouldn't be suited for an Insolvency Act application, they are conveniently bundled together into a hybrid claim for entirely rational reasons. It makes complete sense to have them managed together because they are identical. It does nothing other than increase costs and complicate proceedings to have them dealt with separately. And this is exactly what had happened here. There'd been all of the ordinary insolvency proceeding type applications brought under the IAA, but at the same time, there had been other elements involving breach of duty that aren't properly an IAA suitable, but shoehorned into the same application. The benefit, obviously, aside from it being convenient in terms of case management, is that there's an expedited and low-cost procedure with the Insolvency Act applications that all litigators would wish to make use of. I've set out some brief examples of the kinds of things that would be involved, but based on what we've covered, this is going to be a mixture of the insolvency proceedings that I've dealt with, along with what I've just conveniently called the other claims. So, established practice completely, and it won't surprise you to know that the litigation funders were arguing in that case via counsel, obviously, that there were a number of reasons this has been the established practice. And I think the judge said that they were forcefully made, and quite rightly. Aside from it being entirely commonplace, it is incredibly convenient in terms of controlling the claims, i.e., where do you want this claim to be heard? Do you want it heard by a specialist insolvency judge, or do you want it essentially at large to be heard in whichever judge gets a hold of it? That's not to say there's anything wrong with the ordinary judges not sitting with a specialist insolvency jurisdiction, but where the types of issues are well trodden to those in insolvency and perhaps not to the more general jurisdictions, it makes complete sense to have it managed in the right place. The user autonomy policy considerations, the courts are encouraging claimants to be picking the correct list and issuing for that reason. And of course, it's entirely illogical to have two claims running that are essentially arising from identical or the same circumstances, running on separate tracks, heard by separate judges on separate locations. You may end up ultimately, due to availability issues, having different barristers dealing with each one. It just makes it so ineffectual. And all of these points were very well made. And what the judge said, in ultimately when the decision went against the funders in this case, I agree with Mr. Curl, who was leading counsel dealing with the case, that the Insolvency and Companies Court has seen hybrid claims by way of insolvency application. And what the judge is expressly recognizing here is, yes, this is how the things have been proceeding before. So in terms of the conclusions that were reached, which I think we probably are all familiar with, the Section 212 issue was dealt with in terms of standing. So on the literal wording, the standing lies with the OR liquidator, accreditor, or contributory. And what the judge has said is quite simply, you can't assign office. So while the claims that were wrapped up under the guise of Section 212, to the extent that they exist on their own, they can still be pursued by an assignee. However, that would have to be done under the Part 7 regime. These are the specific paragraphs, if you want to read the section in full, 51, 52, and 53. So, but for the assignment to the applicant, the joint liquidators may use the section to bring the black order claims in their own name, making use of the insolvency application procedure. So here we have a situation where they're saying, had they not been assigned, the liquidators could have done it themselves. But in circumstances where the applicant, who of course in this case was the assignee, is not a liquidator, OR, contributory, or creditor, they essentially lack the standing to bring that claim in that particular mechanism. In terms of the use of IAAs, this was a slightly more wide-ranging point. Having looked at the wording of 1.35, the judge reached the conclusion that there is that distinction, building on the decision of His Honour Judge Mark Corson QC in the Retaunton Logs limited decision. So the question is, given that it's been resolved against us, if the proceedings are now wrongly brought by the Insolvency Act application format, well, what's to be done? And I suppose the two questions following from that are, well, if you've already brought the claim, that's one issue. If the claim is yet to be brought, then you can obviously give slightly more thought as to how it's going to be dealt with. Under the insolvency rules, you have the benefit of Rule 12.64. So this is the ability of the court to treat a procedural irregularity as cured where it considers there's no substantial injustice. Now you are or substantial prejudice. This is something that is used regularly, but by the wording of the rule, it is very much pinned to insolvency proceedings. So if the conclusion is that a claim that is brought in this manner is not an insolvency proceeding, then you obviously think, well, where does the court's jurisdiction to cure any procedural irregularity arise? The Retaunton Logs limited decision is authority, certainly prior to this one, that properly construed the jurisdiction that is engaged is 3.10 of the CPR. And what that provision says in general terms is that where there has been a procedural irregularity or an error of procedure, it doesn't necessarily invalidate the step, but the court is able in any event to cure it on the terms that it considers. And essentially what was done in Taunton Logs, where the claim had been, as the judge construed it, wrongly brought, is the judge considered, well, the way to cure it and bring things back to where it should have been is to pay the issue fee. So the judge's conclusions on reaching those two decisions. He says specifically, I reach these conclusions with regret. The criticisms of the procedure are well made by Mr. Curl. They do not promote a convenient or sensible or economical use of court resource. In modern parlance, the result fails to ensure that the claims of this nature are dealt with expeditiously, allotting an appropriate share of the court's resources. With a mental tab stop there, what the court is expressly, I think, referring to there is part 1 of the civil procedure rules to do with the overriding objective. An office holder and assignee of claims will be forced to issue claims arising from insolvency using different procedures in different lists within the business and property courts, with the risk that without a transfer, they will be case managed at least by different judges, although the claims arise out of the same facts. So again, all of those points are points that were made by leading counsel on that occasion. They are all complaints or concerns that I have about the implications of this decision. And no doubt they are all complaints and concerns that everybody on this conference will have, because it makes it far more difficult and frustrating to achieve the same thing that was already entirely achievable before. Why are these conclusions reached with regret, save for those? Well, comparing the procedures and how they are managed, and I pause to say, I'd skipped through the decision and the outcomes of such, again, on the basis that I imagine most of the attendees will be very familiar with it. What I'm now hoping to do is to give a cursory overview of the different procedures and what we're going to be doing about it, or what might be my recommendations for dealing with it. And I imagine this might be where, if there are any questions, they will be focused. So what everybody will be familiar with, certainly on this call, is the Insolvency Act applications procedure. So typically you would expect the application to be issued, supported by your witness statement, and that essentially stands as what would be the equivalent of the claim form and particulars of claim. There will then be a directions hearing to manage the case, evidence and response, evidence and reply, a second directions hearing, issues you might encounter there, undercooked evidence, requirement for further evidence if it's not already been dealt with at the first directions hearing, the attendance of certain witnesses, and then you have the trial. That is probably the key reason that it's described as expedited, because the number of court hearings and the number of steps that are formalized is far more flexible. So it might be, and you'll see my note at the bottom, if the claim is particularly complicated, so that might involve where, let's say, there's a misfeasance angle which involves a swathe of wrongdoing and difficulties in proving the case. Well, it might well be in that circumstance that the judge case manages it to direct points of claim and so on, and that the procedure thereafter would deal with essentially mirroring what a Part 7 claim would look like. In terms of what an ordinary, and I stress ordinary Part 7 claim would look like. You have the claim form, particulars of claim, defense with the ability to then counterclaim, the possibility of a reply, albeit if a counterclaim is brought, you will need to defend the counterclaim. There'll be a CMC or a CCMC, cost budgeting exercises, disclosure, evidence, interim applications, a PTR, along with the various checklists and such that are required, and then the trial. And so when I say that is ordinary, I would expect those steps to be taken in almost any claim. There might be the odd step which is missed out. For example, the court does have something of a practice in smaller claims of skipping the PTR phase as simply being, well, this is simple, we don't need to review everything, we're all ready for trial. But as you can see, this requires a lot more oversight because in the other circumstance where you're dealing with the Insolvency Act applications of the first directions hearing, to the extent that the evidence isn't already in, and certainly by the second directions hearing, the judge, which in this context would be a specialist insolvency judge, has had an opportunity to consider what the issues are going to be, as have the parties, and agree what the necessary steps are. In terms of one of the main distinctions that I think office holders are going to be concerned with, will no doubt be standing out of the page, is disclosure. Because in the Insolvency Act applications regime, disclosure is very much at large. It might be, and the obvious reason for that, of course, is the insolvency practitioner comes to the books and the records as in a complete stranger with no knowledge of them. It is often the respondents themselves that have had the input in creating those documents. So an entirely plain disclosure option is to simply say, well, you're welcome to inspect them. Here they all are. That is relatively easy to achieve, and it is relatively low on cost. On the Part 7 regime, disclosure is going to be far more onerous, I'm afraid to say. You might have something as straightforward as standard disclosure, which is giving disclosure by list and category, but it requires you to undertake an expensive disclosure exercise. How you are going to engage in that is going to be somewhat fact sensitive, and to some degree you may need to be guided by your lawyers, because quite simply, you're going to be coming into possession of a number of books and records. You may have no idea what they say initially, and the extent to which you need to give disclosure of them requires you to consider all of them in perhaps a way that simply making them available does not. So while ordinarily you may have lower banded fee earners reading through the documents, working out what is required or not required, in the disclosure context, the obligations on you are going to be much more onerous, because ultimately your lawyer is going to be required to sign and certify that it's been fully undertaken. So drawing on some slightly more wide implications, the established practice that we had there, I think, is quite safely no more. You're going to have considerable difficulty avoiding the issue fee. Certainly it's not available to escape if the company elements are envisaged, which would need to be brought by Part 7, because if you do, then you chance the risk that 3.10 is exercised against you. One of the reasons for granting relief very readily in taunted logs was that there was no suggestion at all, certainly on the part of the office holders, that there was any intent to be avoiding the issue fee as an overriding concern. They'd taken advice in that case of both solicitors and counsel, who advised them or had no issues in pursuing the mechanisms that they did. Unfortunately, it went against them, but the judge in that case was very ready to grant relief. That might not be the case if it is quite clear that the only exercise is one of avoiding issue fees, which, while I'm sure it wouldn't be the only reason, it is a very compelling reason to do things in one way or another. Having things in an ordinary business and property list has the impact of PD 57 AC. Now that does have carve out for insolvency proceedings, but query whether what you are running is a simple debt claim, whether you'd be able to hold on to that carve out. My view is you probably wouldn't. And that gives complications for the manner in which witness evidence is given. So in an Insolvency Act application, as you'll all be familiar with, when you produce the witness statement, being essentially a stranger to the document, it is rarely a narrative account of what you personally know, because of course you are the office holder and you've no idea what's been going on, save as what the books say. So the witness statement essentially stands as something of the particulars of claim, where you're saying, okay, this is what the books say, this is what I make of them. Now it's over to you, respondent, to justify why you've done the things that you've done, because I consider there's been wrongdoing or what have you. You simply cannot do that under PD 57AC. So to some degree, your witness statement is going to say, I've had advice preparing this witness statement, all the usual formalities. These are the books and records annexed. I believe that they're true to the extent that they've been created by the respondent. You can't really say anything other than that. And then you are essentially appending a stack of documents and hoping for the best. You have the enhanced or pilot disclosure obligations. I say enhanced because I've already touched on them. One thing to be wary of is that the court is habitually introducing and de-introducing disclosure pilots where they give a very specified form, and it's something that your lawyers are going to have to be on the lookout for, because occasionally, and it is very easy to do, it can be gotten wrong because they only apply to select claims. Certainly a move away from the norm. So it is going to require some level of familiarity with elements of the CPR which perhaps you didn't before. The CPR regime is going to be much more regimented and less flexible, and there is a very big emphasis on timetabling. While it wasn't the case that under the Insolvency Act applications procedure, you could play thick and fast with deadlines. However, under the CPR, given how prescriptive things will be by default rather than by request, you're going to be watching out for much more deadlines and procedural steps that need to be taken. And if you are on the wrong side of them, then there's the expense of begging relief from sanctions under 3.9. You need to be aware, of course, of the default position as to evidence. It is entirely regular for the IP to excuse themselves from giving evidence because simply there's nothing, they can't speak to the documents. However, that is something I think you will need to be actively seeking if you do bring a Part 7 claim, because the default is you will be expected to attend. To the extent I can give you any silver linings about this regime, while the litigation process is longer, it does compel engagement much more quickly. So if the respondents don't engage, there is the default judgment mechanism. So 14 days after service, if they don't respond, you can request judgment, and the court treats it essentially as an administrative exercise. You will simply receive it back, and then the onus is on them to set it aside. We are very familiar with turning up to the first directions hearing, having written LBAs, everything else, the director not engaging and attending on the first occasion, and all of a sudden its attendance and no, there's all of these issues. Well, that option isn't quite open, because by the time that point arrived, you already would have been entitled to the default judgment. So to the extent, and this is something for the individual IP, looking at the percentage of would-be miscreant directors that don't engage, if you have a high percentage of them, it may well be that there are some benefits to adopting this procedure more generally when you are dealing with elements of debt. If they simply don't respond, well, case closed. While you would be paying an issue fee, you would be getting judgment much more quickly than having to ask for it on a non-attendance basis at the first hearing, which is listed some weeks after issuing the application. And likewise, if it is going to require the strong arming of litigation to get a response, well, that can be accomplished much more quickly because there is a deadline for them to respond. If they do acknowledge service, they've got 28 days, but again, if they don't respond, default judgment is available. You've also got, for your absolutely nailed on claims, you've got the summary judgment exercise available. Ooh, there we go. So moving forward, how do you manage the distinction between the 212s versus the Part 7 claims? Sorry, not the 212s. How do you manage the distinction between the Part 7 claims and the IAAs? So if your claim has already been issued, it is not, fortunately, by default a nullity. However, I would be preparing to pay the appropriate court fee to regularize the position. I imagine it might be that a well-advised respondent is simply content to proceed on the route that they already are and it doesn't come up. However, those that are looking to just make things more frustrating or to front load fees to make it slightly more difficult, well, the assignee needs to be prepared to pay the appropriate court fee. If the claim has not already been issued, well, you can consider whether that element might usefully be dropped. It is entirely normal for the lawyers in the room to plead everything under the sun because you want to be absolutely belt and braces. But there are circumstances where what might be a completely narrow debt claim is also misfeasant under 212, and while the assignee might not be able to bring it, it could simply be left off. If you decide it is needed and or desired, how are you going to do it? Well, I think my recommendation is to issue the IAA in the ordinary way. first. You can then bring the Part 7 claim, and because there will have been a date listed for dealing with the IAA and case managing it, you can then, on the covering note where you are issuing the Part 7 claim, say, this other action is already live dealing with the same facts, please list it as returnable for this first occasion. You then hopefully get in front of a specialist insolvency judge who sees the issue, and to the extent the claims aren't merged or rise and fall together, they can at least be case managed alongside each other. So here, while you've got the front-loaded issue fee and they initially start off on separate tracks, it is hoped that you can get them back to where they would have been already. Is it here to stay? Well, I hope not, and I imagine that's the sentiment of most of us on the call. The judge expressly recognises it was a decision they reached with regret, so while it is correct on the wording of the rules, it is not something that is welcomed by the court, no doubt, because now in circumstances where they might have had one application issued, they are now having one application and a Part 7 claim issued, and it increases their administrative burden, and it increases the backlog of court cases waiting to be called on. Frankly, it increases the burden on absolutely everybody, because the paying party at the end, if they are the respondents, also have what might be an extra £10,000 for the claim being issued. So it certainly doesn't serve them unless they are simply trying to frustrate and delay. There has been a recent consultation, which I think ended in June and was temporarily convenient with this decision coming out. I would be absolutely amazed if it wasn't considered or referred a million times for scrutiny. It is arguable, I think, that it may well be that an amendment to the Insolvency Act is required as opposed to simply the rules, the latter being a creature of the former. And given that, it is probably unlikely to be a short-term fix where you can simply slap plaster over the top and get back to normal. So I think it probably is here to stay for the medium to long term. I hope I'm wrong, but there we are. So take going forward from today, it is adapting to the CPR. How are you going to do that? Well, there's simply learning by doing, but it may well be quite simply some further engagement with the lawyers. While that is, of course, very self-serving of me to say, what I mean by that is if the problems are identified at an early stage, it will save the litigation costs further down the line. It might well be if the respondents are properly and/or defendants in the Part 7 context are properly advised, they are willing to agree directions and/or agree certain allocations that will avoid these issues. However, it is going to require from those of you who are exclusively insolvency a little bit more flexibility. The CPR is something you will already be very familiar with in the sense that it is expressly applied by several portions of the Act and the rules. That said, there are wider parts of it that you won't have come across. So I would recommend, to the extent you are now going to be flirting them, being as familiar as possible. So be familiar with default judgment, be familiar with summary judgment, analogous as it is to many other parts of the insolvency proceedings you will have been dealing with, and get prepared, I'm afraid, for the medium term. So the key takeaways in terms of the decision are set out here, but I think the key takeaway from me is to watch out at an early stage as to how you can not so much subvert the decision, but get around it, whether that is dropping claims that would force it onto Part 7 if you don't need them, to ensuring when you do issue them, be as proactive as possible on getting them on the right track. Now, I think I've spoken for too long, so it might well be, because I don't want to overrun, if we have any questions, or certainly knotty questions, if you collate them, Caroline and Elizabeth, you are welcome to send them over to me and I can respond to them in writing and they can be pinged on to the asker. Alternatively, if they're a short one, I'm happy to respond now. I think I've only got 2 minutes, however.
Thanks very much, Joel. That's extremely useful. And I'm sure very technical for lots of our IP guests on our webinar this afternoon. I think one of the points that you touched upon was the Practice Direction 57, which is the one that brings in sweeping new rules for the way in which witness statements are prepared. And I suspect that that may have gone under the radar for some of our insolvency guests today. And I wonder whether it might be worth you just explaining in a little bit more detail the significance of that, because it seems to me that where you've got a claim which now has to be brought under Part 7, where previously that would have been brought as an Insolvency Act application, there may be some difficulties in obtaining the evidence that's required to prove the claim, because as you mentioned, the insolvency practitioner will have no direct knowledge of the underlying facts, and I should imagine it will be extremely difficult to find anybody else that's able to give direct evidence of the claim in order to prepare a witness statement that complies with the new practice direction.
You're absolutely right, and everybody, I think, certainly at my end, is discussing how this best can be done. So what you would be doing with the witness statement, and so stepping back with with the PD 57AC, what you have is a distinction between those claims that are running as insolvency proceedings, which will carry on in the ordinary way, but this altered witness statement where you're dealing with only factual evidence. When I say factual evidence, that means the first-hand knowledge of the person giving the statement. So as, let's say, an assignee of the claim, or as indeed a liquidator, you're going to have zero first-hand knowledge of what the claim is. The only knowledge that you're going to have is the contents of the documents. So what the witness statement will say, in slightly more elegant terms, is I am the assignee and/or office holder. Here is the information, which isn't particularly useful. One of the things that came out of the BPC forum in Manchester, which I attended, was mooting the idea of if counsel is engaged at an early stage, is essentially producing a skeleton argument at the same time, because what you're no longer allowed to do is you're not allowed to comment on the documents as they arise and put that before the court, because really that was the point of the evidence before, is to say, well, here's all the documents, but for you, judge, here's what I make of them. So that is something that counsel will be doing in their skeleton argument anyway, and while the other side obviously means it will have the skeleton argument at a very early stage, in many cases, the contents of the skeleton arguments isn't particularly surprising, and it will only be slightly more distinctive when you are actually commenting on their evidence, which you wouldn't necessarily have for the first directions hearing. So that's something which is maybe something to be considered. But you're absolutely right, it is going to be an enormous upset where I think principally what I'm dealing with in this decision is the assignee of a claim which now has to be brought by Part 7, where ordinarily it could have been brought or shoehorned in with other things before, is they're going to have to think carefully about what evidence they can give, because the practice direction we are concerned with has very express sanctions for non-compliance. So if you go ahead and give a narrative account of all of the documents, the other side are able to apply to have the evidence struck out, in which case you've just got nothing, or to sanction you in costs or direct you to do it again. So you're absolutely right to identify that. And if persons on the call that this will affect have not already refreshed their memory of that PD, I would fully recommend that it is, because it will substantially alter how you run these kinds of claims.
Yes, well, thank you, Joel. And just sort of flowing on from that, you mentioned that from a practical perspective, in order to make sure that we don't have two sets of proceedings running in parallel, that it might be possible for the two sets of proceedings to be case managed together and dealt with in the insolvency court. Do you think that if that were to happen, the PD 57 might then be disapplied, so that both claims would be dealt with in the insolvency court under the usual rules for preparing evidence? Or do you think that the PD 57 is still going to apply, even though both cases are going to be dealt with as one insolvency application?
It's a very good question, because part of that hinges on where it's being heard. So the practice direction we're concerned with is a creature of the business and property courts. The insolvency and company courts is just a species of the High Court. But it's the fact that it's insolvency proceedings that means you can get away with not complying with 57AC, because there's an express carve out. I think what I would be inviting the judge to do, and to some degree we're still finding out what the judge is going to do, but if you have done what I've recommended, which is to issue your Insolvency Act application first, then that ensures that the first hearing is going to be heard by someone with some knowledge of it. And then when you are giving the directions for the evidence, because if they're both listed as returnable at the same time, what you are doing is getting in before the case. So let's say that you've got an element which is debt, which is on Part 7, and would attract something like standard fast track directions where it's £10,000 to £25,000. before the court gives those directions, you've managed to get it in front of the right judge, and you can say, well, judge, we have this second case which is identical, and you may as well hear them together. Let's manage them together, treat them as all of the same claim, and give specific directions on it. It will depend on whether the proceedings are essentially merged. They might be allocated a new claim number, and the judge might be extremely proactive. If they are not, then it is still probably arguable that 57AC would apply if they're simply being on the same track, but still separately. But it is something that can at least be raised with the judge, and everyone's expectations can be set clear, because frankly, if you raise the issue and the judge goes, well, no, I've done a million insolvency cases, I'm very familiar, and I absolutely do not want a stack of documents with a covering note from the assignee of the claim, then they're going to give you fairly tailored directions that can hopefully get around this issue. But it is all about proactivity, and part of the benefit that we do have while we have this added complication is that to some degree I suspect the insolvency judges are going to be on side, because while I don't at all question the correctness of the decision, and I imagine most of the bench don't either, they will be slightly lamenting the changes that it makes to practice, because essentially what you're asking the court to do is to give very tailored management decisions to bring the proceedings back to where they would have been but for this decision. So what I would be envisaging certainly is that while there's an initial separation, if you can get them to converge at an early stage before they've been proactively managed in the BPC, you may well be home and dry. It might take some doing, particularly if your judge is unfamiliar with the issue, but that's why if your IAA is issued first and you get everything listed at that return date, the overwhelming likelihood is the judge managing it will know what you are talking about, and you can hopefully have it dealt with in that way.
Thank you, Joel. That's really useful. Well, let's just all keep our fingers crossed that we do eventually have a rule change and a change to the legislation, just to make all our lives very much more straightforward.
My fingers certainly are crossed. I am going to give way to whomever is next, but what I would say is if anybody has any questions arising out of this and they want to send them over to Elizabeth, Caroline, or myself directly, please feel free. It's an interesting subject. I should caveat it to say we are still figuring this out. This is going to be something I think we all need to keep a tab on, but no doubt Elizabeth and Caroline will be able to help us at an early stage. And certainly if it were coming to me, this is what I would be saying.